The blues has always been totally American. As American as apple pie. The question is why? Why should the blues be so at home here? Well, America provided the atmosphere.
Team took a bullet for the dream that we would one day all be free, free from prejudice, free from sexism, free from bigotry. I die for creativity, I die for freedom to be free. I died and left a legacy. Oh, but baby, I'm still living. Pain, and tears of pain, and a dash of struggle, just be patient. Your destiny will manifest, yes, for us in the city.
I was going to use another background music. I didn't know it was going to be this one, because I normally reserve this for when we go into hell. So y'all please charge it to my head, not my heart. Okay, I don't think I have it. See, my other instrumental was on it's on StreamYard, so this is what it's going to have to do for now. Before I get started, I will say this. Unfortunately, it looks like Marcellus is going to be executed on today. Despite individuals petitioning for his sentence to be reduced from death to life in prison. We're not saying for him to get the fuck out. but we're saying for his sentence to be reduced because the purpose of prison, the purpose of jail, the purpose of that is to help rehabilitate people, to be able to help understand why people do what they do, and then try to find a way to change that trajectory so that we can have more healthy, upstanding citizens. And when I'm on my channel, I try my absolute best to speak as objectively as possible. But I think because we live in America and racism has been a part of the Black experience for so long, I will do the best I can, but it's hard to believe that this does not have to deal with race when it does. Now, this is going to be somewhat of a lengthy live. Okay? I don't know how long. There are going to be 3 things that we're going to read. First, we're going to read who Marcellus is, because I discovered who he is this past week. We're going to discover this newly found evidence that exonerates Marcellus from the murder of the individual that we will discover as we read these articles. And one of them is an actual from case, I think it's case study or something like that, Casetext, that kind of summarizes the legal proceedings, especially with one of the appeals made from Marcellus's legal team. Make sure y'all got something to chill with, okay? So again, I'm going to also say I'm probably going to speak somewhat ignorantly as well, because I tried my best to research as much as I could in a very short time frame, but from what I'm seeing, it just seems as if though Marcellus is not the one who unalived the individual. Now, may he have been an accomplice to it? Possibly. But we're also going to look at and also critique the criminal justice system, because when you are bringing people into court, you have to have all the facts that prove beyond a reasonable doubt that this has happened. But what has allowed for this man to be arrested and sentenced to death is the accounts from 2 individuals who, that if you look at their criminal history and record, they have no sort of substance or weight to their name as well. And I mean, I understand in cold cases they will use new information or technology to try to solve those cases, but I mean, damn, does Marcellus have to die in order for it to be proven that, hey, we did kill an innocent man? At least a man that was innocent in the murder of this individual. Now, before we get into that, copyright disclaimer: under Section 107 of the Copyright Act of 1976, allowance is made for fair use for purposes such as criticism, comment, news reporting, teaching, scholarship, education, and research. That's not me farting, it's just my floor is old as hell. Fair use is a use permitted by copyright statute that might otherwise be infringing. Non-profit, educational, or personal use tips the balance in favor of fair use. All the videos, songs, images, and graphics used in this live belong to their respective owners, and BubzDaGawd does not claim any rights over them. Okay, the first article that we're going to read. Well, before we do that, let me look at the comments. Shout out to Queen Stevie being in the building. Queen Stevie says, I am mentally drained and tired, and I totally just feel like giving up and leaving and going to another country. November, Georgia, they are doing everything possible to try to tilt this election to make him win. Play literally have to hand count the ballots 3 times to try to find something that isn't there. I was one of those that called and signed the petition, and I should have put the petition down below in the comment section, but it just seems, unfortunately, that he's still going to be executed. I mean, I believe that anything is possible, but also looking at it from a realistic standpoint, it seems like this is going to be the case. If anything, it should make us critique the justice system even further. You remember when I showed that video with all of those black leaders and their different ways of viewing things, all sitting down at one time saying that, well, we can work from inside the system. It's like, but look at situations like this where you have the opportunity to work inside the system and it still don't work. So anyway, the first one is from the Innocence project. Okay, let me change the music because I don't know if I want this music playing. Because like I said, that music is more so when we reading people. Let's do this one. What's this one sound like? We can do this one. That works. Sorry, y'all. Let me move this on up here. Y'all give me a second. There we go. It's from the Innocence Project, and it reads, "Who is Marcellus Williams? Man facing execution in Missouri despite evidence of innocence. Prosecutors' confessions of racial bias at trial and victim oppression. Mr. Williams is scheduled to be executed on September 24th, which is today. Governor Mike Parson has the power to stop this tragedy now." Okay. Article update on September 18th of this year. Case update from September 12th. The Circuit Court for St. Louis County, Missouri, denied prosecuting attorney Wesley Bell's motion to vacate Marcellus Williams' conviction and death sentence. From July 2nd, I guess we're going back in a sense, are we? Yep. Case update from July 2nd. The Circuit Court of St. Louis County, Missouri scheduled a hearing for August 1st of this year to assess the clear and convincing evidence of actual innocence that led prosecuting attorney Wesley Bell to move to vacate Marcellus Williams' wrongful conviction and death sentence. There is no reliable evidence proving that Marcellus Williams committed the crime for which he is scheduled to be executed on September 24th. The state destroyed or corrupted the evidence that could conclusively prove his innocence, and the available DNA and other forensic crime scene evidence does not match him. Even the victim's family believes life without parole is the appropriate sentence. Now, time is running out, and I ain't gonna read that part because time is running out, unfortunately. Here is what we know, or what we need to know about the case. First, what's up, Clement? What's going on? I hope I said that right. First, a crime scene covered with forensic evidence contained no link to Mr. Williams. Mr. Williams has been seeking to prove his innocence throughout the 23 years he has spent on Missouri's death row. On August 11th, 1998, which we're going to get more into when we read the appeal from Casetext.com, Felicia Gale, a former reporter for the St. Louis Post-Dispatch, was found stabbed to death in her home. The perpetrator left behind considerable forensic evidence, including fingerprints, footprints, hair, and trace DNA on the murder weapon, a knife from Miss Gale's kitchen. None of this forensic evidence matches Mr. Williams. Secondly, the prosecution's case against Mr. Williams was based entirely on the unreliable testimony of two incentivized witnesses. The case against Mr. Williams turned on the testimony of two unreliable witnesses who were incentivized by promises of leniency in their own pending criminal cases and reward money. The investigation had gone cold until a jail inmate named Henry Cole, a man with a lengthy record, claimed that Mr. Williams confessed to him that he committed the murder while they both were locked up in jail. Cole directed police to Laura Asaro, a woman who had briefly dated Mr. Williams and had an extensive record of her own. Both of these individuals were known fabricators. Neither revealed any information that was not included either in media accounts about the case or already known to the police. Their statements were inconsistent with their own prior statements. with each other's accounts and with the crime scene evidence, and none of the information they provided could be independently verified. Aside from their testimony, the only evidence connecting Mr. Williams to the crime was a witness who said Mr. Williams sold him a laptop taken from Miss Gale's home. But the jury did not learn that Mr. Williams told the witness he had received the laptop from Laura Asaro. 3. Mr. Williams had repeatedly faced imminent execution as he had tried to prove his innocence. 9 years ago, the Missouri Supreme Court stayed Mr. Williams' execution and appointed a special master to review DNA testing of potentially exculpatory evidence. I'm gonna mess up some words just to let y'all know. The DNA testing conducted in 2016 showed that Mr. Williams was not the source of male DNA found on the murder weapon. However, in 2017, after the testing was completed but without conducting a hearing or making any findings based on the outcome of the testing, the appointed special master sent Mr. Williams' case back to the Missouri Supreme Court. That court, also without considering the DNA testing results, again scheduled Mr. Williams' execution. On August 22nd of 2017, mere hours before he was to be executed and after eating his last meal, Mr. Williams received a stay of execution from then Governor Eric Gretning. Governor Eric recognized that the new DNA results raised serious doubts about Mr. Williams' guilt, and he convened a board of inquiry to investigate the case. Under Missouri law, the stay was to remain in place until the board of inquiry concluded its review and issued a formal report. However, in June of 2023, while the board of inquiry's review remained ongoing, Governor Mike Parson, without warning or notice, dissolved the board without a report or recommendation from the board. Immediately after Governor Parson dissolved the board of inquiry, Missouri Attorney General Andrew Bailey sought a new execution date. Mr. Williams filed a civil suit against Governor Parson because the dissolution of the board without a report or recommendation violated Missouri law and Mr. Williams' constitutional rights. After a Cole County judge denied the governor's motion to dismiss the lawsuit, the governor persuaded the Missouri Supreme Court to intervene. On June 4th of 2024, the Missouri Supreme Court dismissed Mr. Williams' civil lawsuit and immediately scheduled his execution for September 24th. This is the fourth part. Although the victim's family opposes Mr. Williams' execution, the Missouri Attorney General has continued to fight to execute him. After the corruption of the key DNA evidence came to light, Mr. Williams and the St. Louis County Prosecuting Attorney's Office reached an agreement to ensure Mr. Williams is not wrongfully executed. Mr. Williams agreed to enter an Alford plea, admitting that the state has sufficient evidence to support his conviction in exchange for a sentence of life without parole. The victim's family supported this resolution of Mr. Williams' case and have said they do not want Mr. Williams to be executed. On August 21st, the circuit court entered the consent judgment based on the parties' agreement. Despite the closure this resolution would have brought to the case, Missouri Attorney General Andrew Bailey sought a writ of prohibition from the Missouri Supreme Court, which that court granted, ordering the circuit court to hold the previously scheduled evidentiary hearing. The circuit court held an evidentiary hearing on August 28th and subsequently ruled that it lacked sufficient evidence on which to find that Mr. Williams is innocent and that his claims of racially biased jury selection and ineffective assistance of counsel had previously been raised and rejected. Accordingly, the court denied prosecuting attorney Bell's motion to vacate Mr. Williams' conviction. The prosecuting attorney is appealing that ruling to the Missouri Supreme Court. 5. Incentivized informants are a leading cause of wrongful convictions. Jailhouse informant testimony, like that leading to Mr. Williams' conviction, is one of the leading contributing factors of wrongful convictions nationally, playing a role in 15% of 15% of the 598 DNA-based exoneration cases. 11 of the 54 individuals exonerated in Missouri were convicted with the use of informant testimony. In capital cases, false testimony from incentivized witnesses is the leading cause of wrongful convictions, with informant testimony present in 49.5% of wrongful convictions since the mid-1970s, according to the Center of Wrongful Convictions. 6. Racial bias contributed to Mr. Williams' wrongful conviction. Mr. Williams, a black man, was wrongfully convicted of murdering a white woman. His jury was comprised of 11 white people and only one black person. The prosecutor, whose institutional practice of racially discriminatory jury selection has been widely documented, successfully removed 6 of 7 qualified black prospective jurors with preemptory challenges. A recent study of 400 death-eligible cases in St. Louis County over a 27-year period also revealed racial disparity in the use of the death penalty based upon the race of the victim. People who were convicted were 3.5 times more likely to receive the death penalty if the victim was white, as in this case, compared to if the victim was black. 7. Mr. Williams is devoutly religious and an accomplished poet. During his 23 years in prison, Mr. Williams has devoted much of his time to studying Islam and writing poetry. He serves as the imam for Muslim prisoners at Potoso Correctional Center and is known as Khalifa, meaning leader in Arabic. He has an exemplary prison record and is widely respected within the prison community and beyond. And 8, lastly here, it says you can help stop Mr. Williams' unjust execution. And it says we have until September 24th at 6 p.m. to stop Mr. Williams' execution. Here's how you can help stop this irreversible injustice, okay? You can call Governor Parson at 417-373-3400. You can sign a petition to stop Mr. Williams' execution, which you can find on the innocenceproject.org. You can share Mr. Williams' case on all social media channels using a social media toolkit, and most importantly, use your voice. With the weight of this new evidence and the unreliability of the witnesses who testified against Mr. Williams, his conviction must be re-evaluated to ensure that justice is truly served. Dedicated professionals from the Innocent Project, Midwest Innocent Project, and Brian Cave, along with attorneys Larry Comp of the Federal Public Defender, Western District of Missouri, and Kent Gibson, make up the team that continues to fight to stop his September 24th execution. They hope that justice will eventually prevail by way of an exoneration. And, you know, even though it appears that he's going to unfortunately be executed at 6 p.m. with me just reading this, I mean, the last time that he was supposed to be executed, something happened. So maybe something will happen in this case. I feel like at the end of the day, if you have new ways of finding out the absolute truth, why not utilize that while you still have it? Now, yes, at that time, they were probably going off of what it is that they had as far as technology at that time. But now that we're in a greater place and this man is still alive and there's an appeal here, and there's evidence that is saying that none of his DNA is on the murder weapon. Now, it would be different if his DNA was found on the murder weapon. It would be different if the DNA was found underneath the victim's fingernails. Now, am I saying that he's completely innocent as far as the home invasion and stuff like that? I'm going to say no. He probably was an accomplice to something, because if his DNA is not there at the house, then how is that beyond a reasonable doubt? But they were only linked because of two not eyewitnesses, because eyewitnesses mean you seen it, but two individuals who said that they heard or they discovered a confession from Marcellus that he was the one that murdered the individual, the victim. Now, before we get into the second part, let me look at y'all comments real quick, because y'all was commenting. Let me see. Let me look at my phone. I can look at my phone, y'all. Hold on. Let's see. Queen Stevie says, what made me so angry is that they denied him clemency. Clement said, America, KKK, America with the 3 Ks. Exactly, Clement. Injustice is at an all-time high in this country. Clement says, I know Brother Williams is a respectful Muslim man, a respectful black brother, and a good father from what I've heard from his family that I keep in touch with via social media. Oh, wow. Clement, if you have any information as far as what you've seen, because again, I'm still somewhat speaking ignorantly. I just found out about Marcellus this week. And recently, in the past like 3-4 hours, I've been kind of doing my research, trying to really be as objective as I possibly can, because at the end of the day, yeah, you're a black man, but you also got to be a black man that's innocent. You know what I mean? Now, it would be a different story if, okay, Marcellus, your DNA is on the murder weapon. Your DNA is at the thing. Your hair follicles is there. They said they found 2 gray pews. We gonna read later on. But, you know, they would have found that would have been beyond a reasonable doubt. The fact that, again, there were qualified black jurors who said, I have the ability to detach myself from this case, which means that I'm not going to use my blackness as the main factor of, oh, well, that's why he a brother. No, like my parents say, if your ass did the time, we love you still. We gonna put money on your commissary. We gonna put money on your books. We gonna send you a letter, and we might call you, might come see you every once in a while. But if you do the crime, you have to do the time, because it's about having a fair trial. But the fact that those black individuals who were qualified to be on the jury were dismissed in these very extreme challenges, and to have 11 white people, why not have people who were Muslim, or people who were Asian, or people who were neither black nor white, to be able to have more of an objective perspective? And since we're speaking about objective perspectives, okay, let's go ahead and go to the next damn article, because this next article is from Aljazeera. Aljazeera. I said Zaria. Y'all know how Bubs talk. I say the word 12 different ways. Okay, tomato, hey. Okay, and I heard someone say that a lot of the individuals who don't live in America giving commentary on America, they're more objective because they're not in it. They're on the outside looking in. So again, looking at Aljazeera, okay, and this was written in August 23rd of 2017. It reads, Marcellus Williams faces execution despite new evidence. Marcellus Williams is due to be executed on Tuesday. And it's crazy. This is August 23rd of 2017, and today is September 24th. And ain't it a Tuesday on today? Is today Tuesday? So damn. I thought a club was supposed to be going up on a Tuesday, not this. But it says that despite new DNA evidence, he's still due to be executed, despite new DNA evidence supporting his claim to innocence. Okay, and this is an update again in 2017. It reads, a few hours before Marcellus Williams was due to be executed in Missouri, Governor Eric issued a state of execution. And it reads, on Tuesday night, the U.S. state of Missouri is planning to execute Marcellus Williams despite a new report from a DNA expert that his lawyers argue support his claim to innocence. In 2001, Williams, who is now 48, was convicted in the 1998 killing of Alicia Gale, and we're going to get more into what happened when we read Casetext. But his lawyers say new DNA evidence could exonerate him. The Missouri Supreme Court, however, has refused to review that evidence, and we just learned that when they was trying to review the evidence, the other governor said, fuck that shit, he's a nigga, just dilute this shit, we're gonna kill him. Even though the family said, no, we're cool with him having life in prison because he'll just be in there for life, so it's a life for a life, but they want to kill his ass. Williams' lawyer, Kemp Gibson, has described the Supreme Court's decision as baffling. Quote, we petitioned the court to look at the new evidence on August 14th, and less than 24 hours later, they decided based on the court files that the execution should go ahead anyway. This is unprecedented, Gibson told Aljazeera. Williams, who was also claimed he is innocent, was sentenced to death in 2001, 3 years after Gale, a former newspaper reporter, was murdered in her home in a gated community in St. Louis, Missouri. He was originally due to be executed on January 28th of 2015, but Missouri's High Court decided to postpone the execution to allow time for new DNA tests to be conducted. Those tests showed that the male DNA on the murder weapon, a knife, was not Williams, but belonged to a third unknown person. Quote, there is no physical evidence, no eyewitnesses that directly connect Williams to the murder. The DNA on the weapon wasn't his. The bloody footprint at the murder scene wasn't from Williams' shoe and was a different size, and the hair fibers found weren't his, says Gibson. It was someone else that killed Gale, not Williams. Now, how was Williams convicted? During Williams' trial, the prosecution based its case on the testimonies of two people. We're going to learn more about them, Henry Cole and Laura Asaro. Cole had shared a cell with Williams after he had been taken into custody on suspicion of being involved in Gale's murder. Cole said Williams had confessed to murdering the 42-year-old woman. The other testimony was given by Laura Asaro, a convicted drug addict who was Williams' short-term girlfriend at the time of the murder. She claimed, among other things, to have seen scratches on Williams' neck that were made by the victim. So again, she's saying that Williams' his neck was scratched the fuck up. Again, you would think that the person doing the scratching, that there would be some DNA underneath the nails, correct? Quote, just like he said, like I said, these scratches would leave DNA traces on the victim, but Williams' DNA was not found underneath the victim's fingernails, just like it was someone else's DNA that was found on the weapon used in the murder, said Gibson. She also claimed she saw Williams with the victim's driver's license, which is impossible because Gale's license was left at the crime scene. Gibson believes both may have been motivated to give false statements in the hope of receiving a financial reward. Quote, the victim's family offered a reward of $10,000 for anyone with tips leading to the arrest of the person who murdered Alicia Gale, Gibson explained. They both got paid by the victim's family after their testimonies. With no forensic or eyewitness testimony linking Williams to the murder, the prosecution based its case on these two witnesses. At the time, we didn't have the technology to do these DNA tests. But even now that there is indisputable scientific evidence exonerating Williams from the murder, the Attorney General still thinks these testimonies hold more weight than the DNA evidence that shows Williams didn't commit the crime, Gibson said. One of those following this case, closely is Sister Helen Prejean, a well-known opponent of the death penalty who came to international fame after she wrote the book Dead Man Walking, which was later made into a film. Griffin Hardy, a spokesperson for Sister Helen Prejean's anti-death penalty organization, Ministry Against the Death Penalty, told Aljazeera, "The fact of the matter is, DNA evidence shows that Marcellus Williams was not involved in this crime. That means that there is a killer who may still be out in the community at large. Missouri should use its resources to apprehend the real killer instead of executing a man who didn't commit this crime." Black defendant, white victim, white jury. Okay. A significant factor in this case, according to Gibson and Griffin, is Williams' race. The victim, Leisha Gale, was a white woman. Williams is a black man who, according to the prosecution, killed Gale when she caught him burglarizing her home in St. Louis, Missouri, the same district where the Ferguson protest against police brutality took place in 2014. Wow. Quote, "The jury that found Williams guilty consisted of mostly white people. This district has a history of getting African Americans off juries, especially when the victim is white," Gibson said. There were 7 African Americans in the juror pool for Williams' trial, but the prosecution struck all but one of them off, with the result that there were 11 white jurors and 1 black juror at his trial. Another issue is the funding of public defenders in Missouri. This state ranks 49th out of 50 with regards to properly funding public defenders. The public defender that got Williams' case has publicly stated that he wasn't able to prepare properly. Let me read that again. The public defender that got Williams' case had publicly stated that he wasn't able to prepare properly. So he simply didn't have the opportunity to properly discredit the shaky testimonies that were used to build this case around, Gibson said. As to why the court has refused to examine the new evidence, Gibson said, "It's baffling to me how the Missouri Supreme Court denied our petition barely 24 hours after filing it, with no hearing at all. Listening to what experts have to say about new evidence is particularly important in a case like this with scientific evidence. It is frightening that someone can have exonerating DNA evidence and a court would turn a blind eye to it. Williams' execution can not only be stopped by the U.S. Supreme Court or Governor of Missouri, Eric. Quote, he is a newly elected governor and he heavily campaigned on being pro-life. Anyone who says he is pro-life would not let anyone be executed, especially not when there is more than enough reasonable doubt like in this case, Gibson said. That does make a sense, baby. If you pro-life, that's pro-life everything, not just pro-life in reference to abortion, but pro-life in reference to any sort of life being destroyed. Hello? Because at least with pro-life, you have the ability to help that person reprimand whatever demons they have within themselves so that they can live a better life, right? Again, prison is supposed to be a rehabilitation center, right? To be able to help people be reintegrated back into society in a more productive way, correct? So that does make sense. Hardy hopes Governor Eric will stop the execution and that a new investigation to find Leisha Gale's killer will be launched. Society may debate the question of whether the death penalty is acceptable for guilty prisoners, but no one can argue with the fact that an innocent person should never be executed, he said. Williams is due to be executed by lethal injection. Aljazeera contacted both the Office of Missouri's Attorney General, Josh Hawley, and the Office of Missouri Governor Eric for this article. Neither had responded by the time of publication. So now what we're going to do, and this is going to be more so of the lengthy part, I'm going to have to take a second to like take a sip of water and hit my joint a few times or whatever, but we're going to be over at casetext.com. Okay, it is Smarter Legal Research, and it is Williams versus Roper. This is the United States Court of Appeals, the 8th Circuit. It was on December 6th of 2012. Okay, so we're going to read that. This is just one of the appeals. I don't know if we're gonna read all of it because this is kind of lengthy, baby. I don't know. It depends on how we get into this, but the links for everything in this live is in I can't even talk. The link for everything in this live is in the description box below so that you can read it on your own time. Don't just take my word for it. I'm also learning things about this case as I read this with y'all, and as well as I hear y'all share y'all comments. Again, if there's anything that I'm saying that is murky, or if you have anything that you feel that could help broaden my perspective on this to be as objective as possible, I ask that you please send it to me or leave it in the either comment section below for those who are the replay gang, or if you're in the chat, leave an article for me to read in reference to this case. And like I said, I'm going to try my best to be as objective, but at the same time, this is dealing with race, and we can't sit up here and say, oh, well, race can't be a factor when this country was built off of racism and is still being sustained through racism. So to sit up here and to do stuff to people and then tell that when it's your turn, oh no, I'm just playing. No. I keep telling y'all, it's equality across the board. And it's also showing that even though this system is supposed to be fair and just, that there are some people in positions of power who are anything but that. And for those individuals, that's when we the people have to hold their ass accountable. And I'm gonna tell y'all what my damn solution is for all this shit. Cause no shade, if we can't get justice in court, there should be another way of getting justice. And we're gonna talk more about that, but let me go ahead and take a sip of water and hit my joint a few times. Make sure y'all hit the like button, okay? It helps this channel to grow in the algorithms. Make sure y'all share the live. Let me put my I should have put this up before. Let's say fear. Oh, that's for videos. Never mind, I ain't got no videos. Never mind. Y'all give me a second, y'all. Hold on. All right, y'all. All right. I had to hit my shit a few times, get prepared for this shit. All right. This is from Casetext, and again, some of these legal terms I'm gonna fuck up. I'm just gonna let y'all know that right now. Y'all gonna get Andrew Caldwell interpretations. Okay, I'm just letting y'all know. Now, and it reads here, okay? Marcellus Williams was convicted by a jury in Missouri of the first-degree murder of Felicia Gale and sentenced to death. The Supreme Court of Missouri affirmed the convictions and sentences on direct review, State versus Williams, and subsequently affirmed the denial of his motion for post-convictional relief. Williams petitioned for a writ of Lord habeas corpus in the district court under that number there. The district court denied relief on 12 of Williams' claims, but granted relief on his claim of ineffective assistance of counsel at the penalty phase of trial. The state appeals the granted relief, and we reverse. First, on August 11th of 1998, Marcellus Williams drove his grandfather's car to a bus stop and traveled by bus to University City, Missouri. Once in University City, Williams began looking for a house to burglarize and came upon the home of Felicia Gale. After knocking on the front door and receiving no answer, Williams knocked out a window pane near the door, reached in and unlocked the door, and entered Gale's home. Williams heard water running in the shower on the second floor, so he went into the kitchen, found a butcher knife, and waited. Gale finished her shower and went downstairs. So funny that y'all exactly know what happened when they ain't got no DNA evidence. Williams attacked Gale, stabbing and cutting her 43 times and inflicting 7 fatal wounds. Williams then washed Gale's blood from his body and concealed his bloody shirt with a jacket. Before leaving Gale's home, he took Gale's purse, which contained, among other things, a St. Louis Post-Dispatch ruler and a calculator, and her husband's laptop computer. Williams returned to the bus stop, retrieved his grandfather's car, and picked up his girlfriend, Laura Asaro. Asaro noticed that Williams was wearing a jacket despite the summer heat. I mean, isn't that crackhead logic? When Williams removed the jacket, Asaro noticed blood on his shirt and scratches on his neck. Asaro questioned him, and Williams claimed he had been in a fight. Asaro also saw a laptop computer in the car. Later that day, Williams put his bloody clothes in his backpack and threw them in a sewer drain. The next day, Asaro tried to retrieve some items from the trunk of Williams' car, but he tried to prevent her from opening it. Before he could push her away, Asaro grabbed Gale's purse from the trunk. Inside the purse, she found Gale's Missouri state identification card and a black coin purse. Asaro confronted Williams about the purse, and Williams confessed that he had killed Gale. He explained in detail how he had waited for her in the kitchen with the butcher knife, and that when she came downstairs, he stabbed her in the arm and neck, twisting the knife as he went. After confessing the details to Asaro, Williams grabbed her by the throat and threatened to kill her, her children, and her mother if she told anyone. On August 31st, 1998, Williams was arrested on unrelated charges and incarcerated at the St. Louis City Workhouse, where he shared a room with Henry Cole for a period of time. While watching television one evening, Cole and Williams saw a news report about Gale's murder. After the news report, Williams told Cole that he had committed the murder. Over the next few weeks, Williams and Cole had several conversations about the crime, during which Williams provided considerable details about the break-in and murder. After Cole was released from jail in June of 1999, he went to the University City Police and told them about Williams' involvement in Gale's murder. As a result of the information provided by Cole, University City Police contacted Asaro about the murder. Asaro told the police that Williams admitted to her that he had killed Gale. The police then searched Williams' grandfather's car and found Gale's post-dispatch ruler and calculator. The police also recovered Gale's husband's laptop, which Williams had sold after the murder. The state charged Williams with several offenses and sought the death penalty. Williams was tried and convicted of first-degree murder, first-degree burglary, first-degree robbery, and 2 counts of armed criminal action. In preparation for the penalty phase of the trial, Williams' attorneys, Joseph Green and Chris McGrath, hired multiple experts, including a mitigation specialist. The mitigation specialist collected records on Williams and his family and introduced Green and McGraw to Williams' family so that the attorneys could collect information about his childhood development and family history. During the penalty phase, the state presented extensive evidence of Williams' criminal history. The jury heard testimony detailing a residential burglary in 1997, armed robberies of both a donut shop and a Burger King in 1998, and a threat to kill a corrections officer at the St. Louis City Workhouse in 1999. The state also introduced certified copies of Williams' 16 convictions: second-degree burglary and stealing over $150 in 1998, second-degree assault in 1998, second-degree burglary in 1998, 2 counts each of second-degree burglary and stealing over $150 in 1991, first-degree robbery, armed criminal action, and unlawful use of a weapon in 2000. A first-degree robbery, armed criminal action, stealing a motor vehicle, and 2 counts of false imprisonment in 2000. The state completed its presentation with victim impact evidence from Gale's family and friends. In mitigation, Williams' counsel presented evidence that Williams was a caring and loving father, and that his execution would have a significant effect on his family. The defense presented testimony from several of Williams' family members and friends, including his son, his stepdaughter, his mother, his aunt, his brothers, and others. They testified about Williams' positive relationship with his son and stepdaughter. This evidence included testimony that the continued contact and visitation with Williams made the children feel loved, and that Williams would encourage the children to read and do well in school. Williams' counsel also attempted to present testimony from Dr. Mark Cunningham that Williams' continued relationship with his children would have a positive impact on them, and that his execution would have a negative impact on them. But the trial court found the evidence inadmissible. According to Williams' counsel, their theory of defense for the penalty phase was residual doubt. They hoped the jury would have a lingering doubt about Williams' guilt and impose a life sentence. The jury deliberated for less than 2 hours and returned a sentence of death. In doing so, the jury found the existence of 10 aggravating circumstances: that the murder involved depravity of mind, that Williams committed the murder during a burglary, that Williams committed the murder during a robbery, that Williams committed the murder in order to receive money or something of value from Gale, that Williams committed the murder in order to prevent his lawful arrest, and each of 5 prior convictions committed by Williams: second-degree assault in 1998, first-degree robbery in 2000 and 2001, and armed criminal action in 2000 and 2001. Williams appealed the Supreme Court of Missouri, which affirmed the conviction and sentence. The Supreme Court of the United States denied Williams' petition of a writ of certiorari, On May 30th of 2003, Williams filed a pro se motion for post-conviction relief in the Council Circuit of St. Louis County, Missouri, pursuant to Supreme Court of Missouri Rule 2915. An appointed counsel filed an amended motion on September 8th of 2003. One of the several grounds asserted by Williams was that his trial counsel was ineffective for failing to investigate and present mitigating evidence of Williams' traumatic childhood. In support of this claim, Williams asserted that his trial counsel intended to present expert testimony to explain Williams' social history and criminal conduct. But the psychologist they hired was unable to establish a rapport with Williams because he was hired too late. According to Williams, if his counsel had properly investigated his background, they would have uncovered and introduced the following significant mitigating evidence: that Williams was subjected to brutal, violent physical and sexual abuse by family members, that he was abandoned and resented by his parents, that his family condoned and encouraged criminal behavior and substance abuse, that he came from an impoverished and dysfunctional household, and that he was exposed to guns, drugs, and alcohol at a young age. This evidence also would have included testimony from Dr. Donald Cross, who diagnosed Williams as suffering from significant mental illnesses, including depression, drug and alcohol dependence, and post-traumatic stress disorder. According to Dr. Cross, these disorders, which, when untreated, contributed to Williams' criminal behavior, and Williams was under the influence of extreme mental or emotional disturbance and circumstantial conditions, such that his ability to appreciate the wrongfulness of his actions or conform his behavior to the law was substantially impaired. So it's funny that when they are looking at the mental and emotional awareness and evaluating them mentally and emotionally, when it's white children who have been proven to have done things, who have had their DNA on the murder weapon, that now we can use their background. Oh, well, they weren't a bad person and they were just great and they just made a mistake. They just went down a wrong path and never had the opportunity to be able to, have someone help them to rectify that so they can be on the right path. But then when it's a black man, who again, DNA evidence, I'm gonna just say allegedly, are showing that he was not the individual who murdered Miss Gail, that now all that can just be pushed to the background. Oh, nope, girl, it don't matter. You should have presented this before. You should have said this before in the trial. No. We're gonna look at his criminal record. So when we talk about the past, when white people do it, we can talk about, oh, well, they had a horrible past and their family, the father wasn't there, the mother's doing all that she can. But then it's like, again, but when it's black people, we even surprised that your black nigga ass has a father, because we heard about y'all don't have dads. The post-conviction court did not hold an evidentiary hearing on this claim, but Williams' trial counsel, Green, submitted an affidavit in support of Williams' motion. Green stated that he did not have sufficient time to prepare for Williams' trial, but he was having problems getting discovery from the state and was working on another death penalty case. Green further averred, I told you I'm gonna mess some of these words up, that if he had obtained a diagnosis from Dr. Cross, he would have presented the evidence at trial along with testimony from Williams' family. The post-conviction court denied Williams' petition. The court explained that Williams alleged that the trial counsel should have presented evidence to explain mitigating factors such as Williams' complete social history, abusive childhood, drug and alcohol abuse, oppositional defiant disorder, and post-traumatic stress disorder. The court concluded, however, that the presentation of this mitigating evidence would have conflicted with counsel's reasonable trial strategy of presenting Williams as a family man who was innocent of such a violent murder. The court also ruled that there was no reasonable probability that the omitted evidence would have changed the result of Williams' sentencing. Williams appealed, and the Supreme Court of Missouri unanimously affirmed. On August 29, 2006, Williams filed a federal habeas corpus petition that raised 13 grounds for relief. The district court, denied relief as to 12 of the claims, but granted relief on Williams' claim that his trial counsel was ineffective at the penalty phase for failing to conduct an adequate investigation and present evidence regarding his background and social and medical history. The court district held that Williams' counsel was constitutionally ineffective and that the decision of the Supreme Court of Missouri was contrary to Wiggins versus Smith because, quote, trial strategy cannot excuse defense counsel's failure to perform a thorough investigation of a defendant's background in a death penalty case. The court also determined that if the evidence of Williams' family, social, and mental history had been presented at trial, that there was a reasonable probability that the outcome of the penalty phase would have been different. This is the second part of it. In an appeal for a district court's grant of habeas petition, we review the district court's legal conclusion, de novo, which is C. Jackson versus Norris. Again, there's a lot of legal stuff here. When a claim has been adjudicated on the merits in state court proceedings, habeas relief is permissible under the Anti-Terrorism and Effective Death Penalty Act of 1996, the AEDPA, only if the state court's determination, which is 1, resulted in a decision that was contrary to or involved in an unreasonable application of clearly established federal law as determined by the Supreme Court of the United States, or 2, resulted in a decision that was based on an unreasonable determination of the facts in light of the evidence presented in the state court proceeding. Williams' claim is governed by the AEDPA and the standards set forth in Strickland versus Washington, which require that a defendant alleging a violation of the Sixth Amendment right to counsel must show both that counsel's performance was deficient and that the deficiency prejudiced the defendant. Because resolution of the first prong is unnecessary to our decision, we assume, for the sake of analysis, that the Supreme Court of Missouri unreasonably applied clearly established federal law in holding that the performance of Williams's counsel was within, quote, the wide range of professional competent assistance. A. We focus our analysis on the second prong of Strickland, whether the alleged deficiencies in the counsel's performance prejudiced Williams. Prejudice exists under Strickland if there is, quote, a reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Under AEDPA, if a Strickland claim is adjudicated on the merits in state court proceedings and there is no challenge to the factual determinations of the state courts, then a federal court may grant relief only if a state court's decision is contrary to or an unreasonable application of clearly established federal law. In the state court proceedings, the Missouri court adjudicated both prongs of Williams' ineffective assistance claim on the merits. The post-conviction court concluded, first, that trial counsel's defense strategy was reasonable and that Williams could not establish ineffective assistance by alleging that a different strategy would have worked better. Second, the post-conviction court ruled, citing Strickland, that there is no reasonable probability that the omitted evidence would have changed the result of Movant's sentencing. The Supreme Court of Missouri affirmed. The state Supreme Court also citing Strickland, set out the standards for a claim of ineffective assistance of counsel, including that to establish prejudice, a movant must show that, but for counsel's poor performance, there is a reasonable probability that the outcome of the court proceeding would have been different. After noting Williams' claim that trial counsel failed to introduce sufficient evidence of his social history in discussing trial counsel strategy, the state Supreme Court explained, quote, "The motion court found that an abusive childhood defense would have been inconsistent with the penalty phase strategy and would not have changed the jury's sentence." The motion court did not clear error in denying this claim without an evidentiary hearing. Although the ineffective assistance claim was adjudicated on the merits, the district court failed to apply difference under when considering whether Williams had established prejudice from the alleged deficient performance of trial counsel. The district court proceeded as though the claim were subject to de novo review under Strickland, holding that the proffered evidence, if presented at trial, quote, would establish a reasonable probability that the outcome of the penalty phase would have been different. This was error. The proper question before the federal courts under AEDPA is whether the decision of the Supreme Court of Missouri on the question of prejudice was contrary to or an unreasonable application of clearly established federal law. If the state court's determination passes muster under this standard, then Williams is not entitled to relief. So again, this is very long, and I'm not about to read all of this. And again, this is established in 2012, so this is one of the appeals that I kind of want to read a little bit in reference to kind of just, giving y'all understanding of how he tried to appeal these things. But now that again we have this appeal here, where new evidence, we're talking about evidence, something that can now be proven beyond a reasonable doubt. We've already established that in that area of Missouri, there has been a lot of unlawful, wrongful convictions of melanated people. And how during one of these appeals, in reference to the new information about this evidence that proves that Marcellus was not the individual who committed the murder, meaning that he did not kill Miss Gale, that there was a board that was being put together to help establish whether that was credible or not. But again, that board was dissolved, and now they're moving forward with the death penalty, even when the families of the victim said, we would rather this person have life in prison, because at least with life in prison, if we're talking about torment here, it will be more tormentive to that person. Death would seem like just a easy way out. You get to know when you gonna die. You get to have a last meal when you die. You get to sit up there and become one with yourself during that time, because you know you're gonna die. So what if the person who is dying accepted that they're going to die, and now they're at peace? Meanwhile, this man is dead, but meanwhile, you still dealing with the hurt and the pain and the memory of what happened to your family member who unfortunately lost their life. Or do you think, if we're going to talk about being tormentive, don't you think being tormentive would mean that you're going to be in jail for the rest of your life, which means you will never get to see your kids graduate? Which means that all type of birthdays and family reunions and all type of events, all you will get is memories being shared in reference to other people telling you, and you got to use your imagination to wonder what it's like. You would never ever have the embrace of a female again, so I don't know what the hell. You better keep your head up and your asshole down. Don't you think that would be more of a tormentive type of thing? But the reason why I'm saying that this is racist is because if the family is saying that they would rather this person have life without parole, if there was a board being put together to even see that if this new evidence again was plausible or not. Wouldn't it make more sense for all of the social justice warriors and the woke people who are mentally ill and just doing all this shit? Wouldn't that be one way to shut they motherfucking mouths? By saying, oh, we looked at y'all new evidence and y'all was fucking around with that, and we saw it. And what if the evidence didn't exonerate him at all? Wouldn't it be best for you to be able to take the evidence that the social justice warriors are fighting for to see, to be able to say, we looked at y'all evidence, and by the way, that evidence, nope, and then prove to us why he still should be murdered, to shut our mouths. Meanwhile, y'all removing that board. And killing him anyway is going to do anything but shut the social justice warriors up. When we go back to the trial again, 11 white people and 1 black person on that trial, and the person who was murdered was white. So you're telling me that those white people were going to be able to sit up here and without, beyond a reasonable doubt, be able to look at this situation objectively? Because again, where is the evidence? You are taking, because since we're going to use Marcellus's background to kind of create his character, why would y'all sit up here and listen to other individuals who have the same or even longer rap sheet than Marcellus and use it as a way to justify that he should be executed? Again, wouldn't the smart thing to do would be able to have jurors who are not black or white, who again can be able to look at it objectively? Because I feel if you were to do that, then Marcellus probably will not be facing execution, or he may not even be in jail. Because if he was this murderous ass person, what made this situation different than the other situations? Was there a toxicology report to see if Marcellus was under, the influences of drugs at that time? And if he got caught for house robberies and burglary, why didn't he murder those people? What do y'all believe possessed Marcellus, if we're going to go about what they're saying as far as the courts? What possessed Marcellus to attack Miss Gail 43 times, and 7 of those times of attacking her were fatal? This would be the right thing to do in reference to humanity. Again, beyond a reasonable doubt, we have to take into account, again, the history of Missouri. The unlawful, wrongful convictions of black people. We have to take all that into account. But again, when you're black, and that's why I'm saying racism, I'm gonna have to roll up again, because I just smoked a little roach part. Let me tell you something. Y'all cannot sit up here and get mad about racism and say, oh, well, that's the first thing that black people go through is racism, when that's been something that has happened and that is still happening. And that when you have white individuals who murder black people in cold blood, those who are part of the law, servants of the public, who also play judge, jury, and executioner. Didn't have a video recently of a police officer shooting a black woman in the face because he felt threatened? Meanwhile, you the one that got authority in that bitch. And I mean, I'm not hearing any updates from anybody in the comments or in the chat, so I'm guessing that unfortunately this man is going to be executed. And even though that seems to be the case, this is a court of public opinion, so we still gonna give our opinion, our perspectives, because again, when y'all choosing your individuals for the process of jury selection, they're regular schmegler people like us. But now new evidence is coming out. And that means even for the cases that go cold, we shouldn't open up no old cold cases. Nope. Every case that went cold, we're not solving it. Nope. 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 It's done. The statute of limitation is done. It's over with. But yet we have shows where people can go back and find a murderer fucking 30, 40, 50 years later. But see, y'all do that for clout. Y'all do that for money. Y'all will do that if y'all turn that into a show. But y'all can't even do it in this instance. The board didn't even reach its decision to be able to say if this evidence was worthy of him having a new trial or not. Because if that was the case, I think it would shed light on the state of Missouri's legal system and how they operate. So now another black man is going to lose his life. But again, I guess us as black people, we should not be so surprised about that, right? Because whether it's from individuals who are white or whether it's from individuals who look like us, it just seems like black life is not valued. I don't see no red pill platforms and red pill spaces doing any lives off of this man. And I'm gonna say it like this, because like I said at the beginning of the live, if you can't get justice in the courts, there's gotta be another way to get justice. And I feel like we need to get justice in a spiritual way. Because if this man can be executed off of individuals who have alleged or have heard some shit, that's hearsay. But there is no strong foundational evidence. There's no, okay, Marcellus, we found your boot print. You got the same boots you had on, the same size shoe. It belonged to your ass. We have that. We have nothing, no DNA evidence, nothing. And when you only got two people who said they heard something, and both of these people are individuals who, if they ass was on the stand, you would try to have their ass put in jail as well, says something. These individuals were not able to find the backpack. But there are motherfuckers who have drained ponds and lakes for less. Were they able to recover the laptop to make sure that it was her laptop? Did we get an account from the person who was pawning it? Did the person come in and he looked, oh, when he came in, he was looking kind of disheveled and, you know, just kind of just nervous and stuff. And, you know, normally when you pawn stuff, I don't know back at that time, but normally when you pawn stuff, especially if it's expensive, you would take someone's picture. And the reason why I say all this is because, no shade, that can be any of us. That can be any of us. We have been proven and been shown multiple times to be low-key being desensitized to our humanity to say that black lives don't matter. If a motherfucking kneel on your damn neck for fucking 5 to 7 minutes, that I can do that because none of you niggas ain't gonna do nothing about it. All y'all gonna do is yell and scream and cry and record, but y'all ain't gonna do shit. That I can follow all the motherfucking rules and be a black man that knows the law, and just because you're a police officer doesn't mean, or that you in law enforcement means that you know all about the law. But then when black people become educated and they use the law against you, especially when you're using the law in the wrongful type of way, now all of a sudden lethal force is inserted, lethal force is enacted. Black people, we have to do something. And again, these people are not saying that, oh, Marcellus should be free. Because again, just the accounts and the stories that we heard, like, how did we know about how he broke the window pane, went inside, went upstairs, waited, did all this stuff, had gloves on? How do we know all of this? Did Marcellus give an account? Is there a new Monsters fucking, or a Conversation with a Monsters documentary episode that's gonna come out on Netflix, where we're gonna be able to sit down and listen to Marcellus out of his own mouth narrate what happened that day? How did y'all know he was able to do all this shit? He went to the front door and knocked, the side door and knocked, the back door and knocked, then went through the front door and knocked the pane out. Then he started grabbing shit. Then he went to the place and got a butcher knife. Then he stabbed her and said, how do you know this? Did Dexter come in and look at the fucking blood spatter and was able to tell the story? Did the nigga from damn Hannibal come in and close his eyes and be the victim itself and walk through what happened? How do y'all know what happened? And because he's a black man with a criminal record, it's easier to label him as a criminal. But a criminal worthy of the death penalty? Wow. Black people, we're gonna have to do something. We're gonna have to go back to our heritage spiritually or something in reference to protecting ourselves with frequencies and vibrations. Because at this damn point, you try to do what the law says. You try to abide by the law. You try to educate yourself about the system to be able to survive the damn system if it's ever used against you. And as we can see, if you're a black person, it's going to be used against you more likely than a white person. Then being told that when race is inserted, y'all always bring up race. Well, I mean, it was y'all forefathers that started this shit. So my thing is, if y'all upset, don't get mad at us. Go take a motherfucking corporate trip to motherfucking Grand Canyon or what, Mount Rushmore or whatever it is with all them damn forefathers' faces on the side of a mountain and go cuss they ass out and ask them, why did y'all do what y'all do? Because now we have to deal with it. That's how karma works. But let me look at y'all comments. Let me see. Clement says, crazy to play with a man's life until the end. They don't even let the brother go peacefully. Stevie said, Josh Hawley, the one that was running, that was also behind the insurrection of January 6th. Wow. Logic Show says, let's be honest, he probably did it. Well, they would have to factually prove that, and there is allegedly new evidence that shows that none of his evidence is on those weapons at all. I mean, his evidence wasn't there at the crime scene based on what I've read. If you know anything that's different than what I've read, I ask that you please submit it so that I can, you know, read it for myself. Spicy says, sheesh. Even still, if the evidence proved he's innocent, why even bring up all his criminal past at all? Queen Stevie says, we are all in the fight of our lives. It's us versus the Republican Party, the authoritarian party. We will not be silent on this. This makes me angry. Spicy says the red pill community ain't talking about it because there's not a way to blame black women for it. I'm surprised, because they were talking about the fucked up past and childhood. They could have found a way to tie that shit in. Queen Stevie says, Spicy, I was just about to say they can bash us in the queer community, but why are they not talking about this innocent black man that is about to lose his life in a few hours? This is a resistance we have to fight, figure out ways to defend ourselves. Yeah, I just wanted to come through with that and just read that. Again, I've been kind of just started following this situation a few days ago because I've shared it on my Instagram stories and stuff. And I mean, it is only 5:30, so we have 30 minutes. So I mean, if y'all still want to go ahead and call and sign a petition, you can go to innocenceproject.org under Marcellus Williams, and y'all can go ahead and call and do what you can or whatever. I ask that you please use your YouTube channels and platforms to speak about this situation and to hold these individuals accountable. You know, I feel like the justice system could do a lot better, but again, we're dealing with justice system, especially in Missouri, that is racist and has a history, a pattern of sitting here and criminalizing black people that are innocent. But what I'm saying is, black people, we got to figure out what we're going to do. We need to start getting back in touch with our African roots and heritage, African spirituality, and find a way to just update that shit to 2024, to modern times. Start speaking shit against these motherfuckers. And I low-key want to do a live about that, but I don't think y'all ready for that live. But yes, please make sure y'all leave y'all thoughts, y'all comments, y'all concerns, y'all challenges. Please leave them in the comment section below. If you can, please make sure you hit that like button because it helps this channel to grow in the algorithms. We are at 818 subscribers on the road to 1K. If you like the vibe over here on BubzDaGawd, please make sure you hit the subscribe button as well as the notification bell so that you can stay up to date with all of my lives and edited content. If there's anything I said in this live that really touched and agreed with you, I ask that you please screen record it and share it on your platforms and tag me in it. I'm BubzDaGawd everywhere. And if you feel compelled, you can definitely hit that Cash App, $BubzDaGawd. We take any and everything. We appreciate it. We be putting in the work, so it would be nice to kind of get a little something back for it, you know what I'm saying? Because it's time put into that, and time is priceless. So if I'm gonna give something that's priceless, I would like a little something back to kind of reclaim my time a little bit, okay? No Maxine. All right, shout out to Queen Stevie in the building, shout out to Queen Spicy in the building, shout out to A Sea of Serpents, shout out to Logic Show, shout out to Clement, and shout out to Multi Gamer 1. Shout out to all of y'all in the building. I really appreciate it. And until next time, everybody, peace.